Three.
Hey, welcome back, ladies and gentlemen. This is Law 254, your favorite legal show that seeks to demystify the law, give you useful tips and guidance on how you can interact with the law on a day-to-day basis, basically putting the law in your hands. My name is Wakili Kitty. It has been a while, but we are back. Today I want to cover a very basic thing that a lot of people having companies encounter, which is transfer of shares. So you could be having a company, you are a director shareholders, or you are a director shareholder, or you have a number of directors in the company that hold shares, and one of you wants to leave the company, or you want to onboard someone else into the company, and that procedure necessitates that you transfer shares. Maybe they are bringing something into the company, either it's an investment in terms of capital, etc. So how do you go about this thing? So for any transaction involving a company, you need to know who the players are. So the first person is the regulator, the company's registry, and the registrar of companies. The second person is the company itself, which is a legal entity by its own rights. The third person is the shareholders, who are the members of the company. And the fourth person is the incoming party, the third party who is coming in. So once you understand that there are those four players in any company transaction, then that's the beginning of understanding what's needed. Okay? The other thing that you need to understand is transactions related to a company are opportunities for government to earn their revenues. So, you need to appreciate that this is also a transaction that the government is looking to make an extra buck from. Okay, so how does this process begin? So there are certain documents that the company's registry or the regulators will require from this company. Okay, so one of them is the annual returns. So the company ensures that the registrar of companies has to ensure that you have filed your annual returns, which is an opportunity for government to gain revenue. So you need to have filed your annual returns, and you also need to have filed your interim annual returns for that particular period within the year that you intend to do this transaction. Okay, then the registrar will also require of you to furnish them with the incorporation certificate, so that they can ascertain that you are indeed a registered company. And then now they would require also for you to inform them how the decision was arrived at. So in how the decision was arrived at, the company is expected to have held a meeting. The directors are expected to have held a meeting, sat down and deliberated on this issue, and then arrived at a resolution. So the company communicates through resolutions. So you will need to file or prepare minutes for the company saying that one party is desirous to transfer shares, and the company now has to give a resolution. It's a form, CR 19 form, stating that they have resolved that this party will transfer some shares to the other party. Also, after understanding the four parties that are involved in the transaction, you now also need to understand the two key players in any transfer of shares, and that is the transferee and the transferor. The transferor being the person that is transferring shares, losing interest, his ownership interest in the company, and then the transferee is the person who's receiving the shares. So what's needed? So the company will need to communicate via minutes, and also the special resolution in the form of CR 19. But they'll also need to notify the registrar of this transaction. So there's a formal notice that they need to issue to the registrar. It's called a notice of appointment of this new director or shareholder who's coming on board. Okay, the director who's coming on board will also need to be consulted, because there are certain instances where someone just gets into a company, and then when things are not moving right, they claim that they did not know that they were dragged into a company. So the director who's incoming will also need to file something called a consent or consent to the appointment. So they need to have consented, they need to have said that they are aware. The director who is ceding their ownership of shares will also have to prepare an affidavit stating that they are transferring certain shares to this particular incoming person. Then at this point, the transferor and the transferee will come up with a form. It's called a Form D, this transfer form, that states that the transferor is transferring certain amount of shares to the transferee. That form will have to be witnessed and signed by the company's auditor. And they'll also need to have a certificate of transfer and a certificate of stamp duty, basically showing that they've actually paid the stamp duty for that transaction to be legal. So the transfer forms are presented for assessment at the lands registry. They are assessed, and then monies are paid, stamp duty is paid, and then those documents are now lodged with the Registrar of Companies. And then if the Registrar of Companies is satisfied that all the formalities have been met, they effect the necessary changes. In this case is the transfer of shares from one party to the other, and then you can verify independently of those changes having taken effect by requesting for a CR12 that then will now include a new share structure, indicating the new shareholder that has come on board. So there are instances when you are transferring the shares and also you are resigning at the same time. So you are a director and you are tired of being a director shareholder in this company. You want to leave this company. So in that case, you will need to prepare your resignation letter. The company now, as I say, there are these four parties: the company, you, the registrar, and the person who's the beneficiary of your shares. Now the company will need to issue a notice of cessation to the registrar saying that you are have since resigned, and they'll also need to issue minutes and the resolution of the company, and you will also fill the share transfer forms stating that you're transferring your interest to this other person, but also you need to show an affidavit saying that it's true, you're resigning, and by your own volition you want to transfer your shares to this incoming director. So if that's the case, if you're resigning and transferring the shares, that's the extra layer of procedure that you're required to do. But by and large, the procedure is the same. You fill a transfer form, the same is assessed for stamp duty, and then the changes are effected by the company registrar. As always, this is Law 254. If you're having any queries regarding a transaction of land, we'll be happy to help. We'll be happy to assist you in effecting those transfers. The costs depend on what you really want to do, from how many shares you want to transfer, how many directors are the transferees, etc, etc, the capital of the company. So we'll be happy to discuss all that, and we'll be happy to hold your hand through that transaction. Thank you.